Hello everyone and welcome to today's webinar series by Immortal India. So today we have a very big interesting topic today. It's on whether Transgender Protection Act is really benefiting the transgenders. So before I move ahead, I would like to quote some words by Lakshmi Narayan Tripathi. She says that I don't believe in reservation. I don't believe in casteism or color. If I have the ability to touch the sky, I will. So today quite a big day because it also marks the 3-year anniversary to Justice Puttu Swami's big judgment which came into force. And today we have with us really very special. So we have with us Miss Koyel Roy talking about ma'am. Ma'am is an assistant professor in Amity University, Kolkata. She is currently working as an assistant professor. Ma'am has specialized in corporate law, intellectual property, criminal law, cyber laws, human rights, and international law. Ma'am is presently pursuing PhD from University of Burdwan. Ma'am is also was an ex-professor at Alliance University, Bangalore, Christ University, Bangalore, and Techno India University, Kolkata. And also, before joining the academic career, ma'am also used to practice in the High Court of Calcutta. Ma'am, it's a great honor having you with us. Over to you, ma'am.
Thank you. Good evening, everybody. So today, one of the very interesting topic I will be starting, and I think this topic actually needs to be discussed with you all, which I felt, and like I am very blessed to have this topic as my PhD topic, one of the PhD topic, like not everything, but a part of it. Especially, I'm doing an empirical research in West Bengal. So this is one of the prior interest which took me to discuss this particular topic with you all. So today, as Immortal India and as well as Manav gave me this opportunity, so I just took this opportunity and just quickly want to start off with the thing what I want to tell it to you. So my screen visible? My screen is visible, Manav?
You have to do it in full
Okay.
full view.
Is it visible? Manav, is it visible? I cannot understand whether it's visible or not.
Yes, ma'am. Yes, ma'am. Continue.
Okay, thank you. Thank you. So my topic today is Transgender Persons Protection of Rights Act. Just in this previous year, 2019, it actually was like enacted, and my question to you as well as to, like, it is a debatable thing that whether it is benefiting the transgender persons or not. So basically, I have quoted here: a girl is always compared to an angel. A boy is always compared to a bold character. Then why not a transgender can be called as an angelic bold person? So this is a very controversial as well as a very nice quote, a very positive quote, a very humanitarian ground quote, which we can say that by Thalsim Raisha, who said that a girl is compared to an angel, a boy is compared to a bold character. Then why not a transgender to be an angelic bold character? So this is the community of the transgender, for them the victory day. So this is the abstract of my today's discussion. So basically, my today's discussion will be of the transgender bill that was passed in the year 2019, because there were two bills. After the Nalsa Judgment, I'll definitely come what is Nalsa Judgment, what happened there in a nutshell. And thereafter, I'll definitely tell you that in 2016, the bill was passed, but the bill was actually having a much more problem, and that was actually not protecting as per the Nalsa Act. And thereafter, in the 2018, the another bill came up, and after the 2018 2019, the act came up. But again, this act was whether it is protecting or not, whether it is going at par the Nalsa or not, that is the main thing. And thereafter we'll look into the British Raj time, that whether at that point of time till modern day, means till today, whether it is protecting the transgenders or not, and how much in sense till in the British Raj, whether the protection was there or not. All these things will be there in the discussion. Definitely the Nalsa judgment will be there, which came in the year 2014, and especially gender identity protection of transgenders were actually the most put forward things in that particular judgment. So we'll look into the particular gender identity and how much the Nalsa judgment has been put forward in the Modern Act 2019. So this will be my foremost criteria to look into, that whether the Transgender Persons Protection of Rights Act 2019 is at par with the Nalsa judgment or not. And thereafter, as because Indian Constitution, the father of the land, I mean, we have to see that whether the constitutional provisions are also at par with the case reference of the judgment, or the principles of international conventions also hold an analysis or not. And thereafter, the 2019 Act will discuss about some kind of transgender activists surrounding this act, what they are doing. And further, the question will also be put that whether the implementation of the Transgender Persons Protection of Rights Act 2019 is whether protecting the transgenders is really happening in practice, or in particular in practical day to day, whether it is actually practically implemented or not. That also will be looked into. So, in this court, where Justice K.S. Radhakrishnan have said that hijras and inaks, apart from binary genders, be treated as third gender for the purpose of safeguarding their rights under Part 3 of the Constitution. So I think hijras, by these things, are all transgenders, and binary genders are basically those genders who are masculinity and feminism. So apart from those, these particular gender known as the third genders are whether they are getting the safeguards under the Part 3. Part 3 is the fundamental rights of the Constitution of India, and whether they are giving them the self-identified gender to them or not, and whether they are getting the legal recognition as a gender identity, like a male or a female, like them as they are getting as a third gender identity or not. That is the foremost thing, that should be given to them to protect their rights. See, whenever we go for form fill up or somewhere, or for application, we generally see that the gender, there are male, female, as well as the third gender, others are also. If third gender is not there, others has been written. So generally that particular thing should be given, so that they should be identified, they should get a self identification. That is the foremost thing. So gender identity is the foremost criteria in my particular discussion today, that whether apart from a male and a female, whether this third gender is getting an identification being a gender or not in this particular act 2019. This will be the foremost discussion. So a bit about the background and the history of that's why I told you that British Raj, from that time, this particular thing was criminalized or it was decriminalized. That needs to be looked into. So here it says that it was like maladministration and cultural inappropriation of the existence of the transgender community, making it illegal, was an impact of the colonial rule at that point of time. But British Raj categorized hijras and other related groups under the Criminal Tribunal Act 1817. So in that point of time, in that particular age, in that then time, the Tribal Act already recognized these persons, but it was not that humane in nature. Particularly, it was not that humanitarian in nature, actually. So this particular act provided registration, surveillance, control of certain criminal tribes and hijras, and had them penalized for 2 years or more with fine under non-cognizable offenses. The colonial rule has written the history of oppression and discrimination towards the transgender community and other sexual minorities. So this was a thing that it was written that it was like non-cognizable offense. If they fine penalized, so they will be of 2 years. So all these things were there, but not in that particular specificity was not there. So thereafter, even after that, in the archaic rule, there was predominantly existing in India, and as a result of which, acts and behavior towards certain societies are still prevalent. So, although we are in a progressive nation, so from that time till now, if you see, we have progressed a lot. Developments, revolution, we have actually witnessed. We have read through histories, we have seen through histories, we are still witnessing it. That what are the laws, which laws are getting repealed, which laws are coming, why these laws are coming, because of the societal needs. So another thing which took place because of the societal needs is the Nalsa Judgment, which changed the overview of the transgender community. So here the Nalsa Judgment, that is National Legal Service Authority versus Union of India, the full form of Nalsa, so and others, which came in the year 2014, 15th April. So has been a boon to the transgender communities by recognizing them as a third gender. Because in the British Raj, they were not given a gender identity. They were there, definitely their name was there. They used to get certain kind of rights, but not that identity as a separate identity from a male and a female. So this particular case, Nalsa Judgment, actually gave a socio-legal validation on who are entitled to be the transgender people. So just moving on to quickly to the what happened to the Nalsa Judgment. Basically, the Nalsa, the brief fact about the thing is it is a landmark judgment, which not only took the constitutions but also the international principles as well. And there are other principles which I'll talk in the other slides, even which was taken in this, which talks about the equality moreover. So transgender development and empowerment, so they were basically, this particular judgment focused on the transgender development and empowerment. And this particular case talks about the term unquote is identity. Everybody needs an identity. I think in this particular world, every individual needs an identity. Though maybe a housewife, though maybe a student, though maybe doing nothing, but everybody needs a self-identity. And that's a main thing. So I think the Nalsa Judgment was taken into account, and this was one of the attempt of understanding that what is identity. So the Nalsa Judgment was the foremost thing which actually proved boon to the transgender communities. So gender identity, as I told you, that it's therefore refers to an individual self-identification, that whether it's a man, whether it's a woman, or it's a transgender or other identified category. So nobody should be felt apart. Everybody should be given equality. And when we say, specifically when we say equality, equality is given only when there is respect, when we give that particular person that self-dignity or that respect to that person. So here, gender identity, when we say, it is the internal and individual experience of gender, which may or may not correspond with the sex assigned at birth. So by birth, we are not getting this gender. It is something which involves the modification of the bodily appearance or the functions by medical, surgical, or other expressions of gender, including dress, speech, and mannerisms. I think this is the thing which actually changed the very concept of gender identity. Gender, we know, men, female, whenever we say about gender, male or female is the first criteria. Thereafter, this Nalsa Judgment changed the entire concept of gender identity by saying that gender is something which is we are not attaining or obtaining by birth, or we are not assigning by birth. It is something which generally by modification, whenever we are growing up, the way we are growing up, the way we are thinking, the way we are sensing, that is the thing, or the way our appearances towards a society is the thing that I feel that this is my gender is. So that is what this Nalsa judgment generally focuses on. Even it says that judges have also recognized that the ambit of identity is not restricted to the four walls. Gender identity, be it with or without surgery, clothing, way of speaking, or other mannerism. So it is not restricted to the four walls. It is not something that my identity, I am not that particular person that should come up to the society and speak about that, yes, I am of this gender. It is not that. Why you will be fearing about your gender? It is a free world. It is free India. You should come up and speak up of that, yes, you belong to this gender. So gender identity, for that, nobody should be criticized. That is everybody's right. So by this judgment, on analyzing this judgment, I have already put importance on the word identity. And the word identity is a pretty powerful word. Yes, that is exactly, that is the most powerful word in itself, I would say. This is my identity. I am somebody's wife. Why? That will be my identity. This is my identity, that I am somebody. So that is the identity everybody should get with reference to the third gender, as because my discussion today is basically with the third gender. So with reference to the third gender, they should also get the identity towards the society. And it is not just a pen and paper formula that, okay, fine, you are the third gender, with pen and paper you fill up the form and you belong to the third gender. That is not the thing. They should also get their rights that they are entitled to. So that is the foremost thing the Nalsa judgment says. And along with that, identity is something that cannot be decided or taken away by someone merely by passing a bill into an act. So this particular identity which Nalsa judgment has already given, the foremost act that 2019 came, whether it is benefiting them or not, that is the foremost question. But there are certain provisions in this act which are not actually at par, meeting with the Nalsa judgment, which is talking about the identity of the transgender communities or transgender persons. So the word identity stands as a local standi, paradox to the Nalsa judgment, and as the essence of determining the identity of oneself gets shadowed under the much debated sections of the Act. So quickly we'll look into the Act and what are the shortcomings or the criticisms of the sections that I have categorized to you. So this is the thing which the protest is going on. The protesting against the draconian provisions of the Transgender Persons Protection of Rights Bill 2016, which they say are step back from the Nalsa judgment. So from the 2016, there was another bill which came in the year 2018. And from there, this act came. Now, whether this act is protecting or whether this act is at par with the judgment of the Nalsa is that we will look into. Where you can see that what's Nalsa. The Supreme Court judgment in 2014 for the first time identified transgender people as a third gender, affirming their fundamental rights and giving them the right to self-identification. So continuously I'm talking about identification. Now we'll look into that, whether means what are the criteria where they are saying that identification they are losing. Why they are saying? See, why they are unhappy. I have already shown you in the picture where it says that the definition of the transgender people is very narrow and unscientific, where he, she is not actually specifically mentioned in the definition. If you see, government screening committee for recognition in human, so they even said that a particular person will be a transgender or not, there will be screening by the government. Criminalization of begging will take away means of livelihood, which leads to harassment. So even this bill says that they generally beg you. I think it's witnessed by everybody. Whenever we are in the traffic jam, by a car or by bike, wherever we are stopping, we can see these transgender people coming and begging, because this is their way of livelihood. So these things will be decriminalized. But these things will be criminalized. That particular thing has been stated in this bill, which is taking away their means of livelihood. Then lenient punishment. Whoever is bullying them, whoever is taunting them, whoever is violencing, whoever is harassing them, there is very lenient punishment for them. And last but not the least, which is talking about no provisions of reservations or alternate employment provisions are also there. So these criteria are making them unhappy. So these are the provisions that needs to be analyzed, and somewhere or the other comparison I have made. So quickly I'll just discuss about these sections that I think that these things talking something, but whether there are certain lacunas in every provisions. Foremost, the first section, as you can see, is talking about section 3, where it states that no person should be discriminated, okay, being against a transgender person. So no person should discriminate against a transgender person. But this section states unclear and incomplete and not appropriately conclusive. Why? Because the discrimination that is as witnessed, or what kind of discrimination, or the proper penal provision is not being mentioned. Discrimination, it just states discrimination. What kind of discrimination? Such discrimination again can be said as a form of discrimination and untouchability. So the word discrimination is not being the ultimate thing, and it is also not even stating the proper penal provisions, that what will be there if a person has been discriminated. So as Manav, when Manav started, Manav was talking about Puttaswamy. Yes, definitely in the year 2017, Justice Puttaswamy versus Union of India. In this particular case, we have seen that Justice Chandrachud opined that the vision of founding fathers was enriched by the histories of sufferings of those who suffered oppression and the violation of dignity both here and elsewhere. So the vision of our forefathers were founded, those histories, from there they are suffering, they are the sufferers. They are violating their dignity from here as well as from outside. So here again we are talking about dignity. Here again we are talking about identity. Here again we are talking about the self-oppressions, the sufferings. So discrimination may be in the form of denial in the healthcare services, public institutions, unfair treatment, restrictions in movement. This discrimination talk about in the Act. Transgender activities have argued and shown resistance against the Act, as the Act does not hold exclusive penalties for such discrimination. So basically, the discrimination that has been defined is for the healthcare, public places, all these things has been defined. But the proper penal provisions, or what kind of sanctions or punishment that can be given if they are discriminated, that is not clear. That is not conclusive. So this person, person or the famous Manavi Bandyopadhyay, everybody knows, is the principal of Krishnagar Women's College. I think she has quoted that, I mean, Manavi Bandyopadhyay has quoted that all my colleagues turned against me. Most of the students, too, were opposed to me. This is her life that she has actually stated. I always tried to create an atmosphere conducive to studies in the college, but they didn't like it. As Manavi Bandyopadhyay clearly stated in May 2015, as Manavi Bandyopadhyay became the India's first transgender college principal. And this is the biography of India's first transgender principal, a gift of goddess Lakshmi. So atrocities and bullying like this with the members of transgender community will be given what effect? That is the question. Such discrimination, although mentioned, but somewhere or the other is ambiguous. It's not clear with the penal provisions. So principal of Krishnagar College, Manavi Bandyopadhyay, shared the experience that was going on. So, a critic of the Transgender Persons Protection of Rights Bill 2019 has said that the chapter that prohibits discrimination does cover discrimination against transgender person on range of fronts. It is even a toothless tiger. It is just a number of teeth scattered about with no power, reason, or authority to take action on their own. So it's just having a tiger with toothless, no teeth, no power, but having an authority. Just like having an authority without a power. So the things which has mainly criticized in this chapter by the critic is lack of enforcing authority, lack of remedial measures in terms of compensation, and lack of punitive measures against the violator. So these are the foremost criteria where the critic have placed his emphasis on. Now I move on to section 11. So section 3 we have discussed, section 11. Now what is section 11 is saying? Section 11 is talking about the complaints, but somewhere or the other it is negligible to help the transgender persons. Can you see the totally opposite poles talking about something, but somewhere or the other something is missing. It's talking about the complaints. It's talking about that violation. You can go to the particular complaint officer who is designated. But this is also vague, that which results to negligible help to the transgender persons. So anyhow, this is resulting to the negligible help. Again, it talks about certain kind of researches which are going on, that whenever the complaint procedure, complaint officer has been designed, there has been no further procedures that how the person will go. Any details of such officer, selection of such officer, or complaint mechanism has not been set up. It is talking about authorities there, but how will it set up? Who are the persons there? Who are the persons designed? Has not been set up or not been actually mentioned. So this is so vague. So much lacunas are there in that particular section. Recognition of identity of transgender persons. I am continuously talking about identity. So section 5 rightly talks about a transgender person may make an application to the district magistrate for issuing a certificate of identity as a transgender person. So being a transgender, I have to go to the district magistrate and then I have to collect a certificate to the same. The Act restricts right of trans persons to self-identification of gender by making it conditional on a certificate issued by district magistrate. So if a district magistrate, rightly, participants see this, if the magistrate does not give a certificate, then that person will not be a transgender person. That is what this particular act is saying. So if a person is unable to go to the district magistrate or district magistrate refuses, then that particular person, if I am feeling that I am a transgender, I cannot say that. So this is where the lacunas lie. Supreme Court notice to center on plea against Transgender Act. This was updated in the Hindustan Times, New Delhi. Short paper cuttings which I took. To contrary to the Nalsa Judgment, where identity was upheld and the recognition of gender identity was done, with the commencement of this act, the entire recognition of the identity and gender comes into one question. So why I need an approval? If I have an identity, if my identity has been recognized, why do I need a recognition or approval by the district magistrate? So Nalsa Judgment has already given them the right to self-identification. Where Nalsa Judgment has already given, then why do I require the certificate from the district magistrate? Which has rightly pointed out by the senior counsel Anita Shenoy, who represented the petitioner actually in this particular case. I'll go to the case where the plea was actually presented by Barua, Justice Swati Bidhan Barua. I'll go to this. In 2020, it happened. So thereafter, I move on to the next section where I have criticized or I found the lacunas there. Section 6 says the district magistrate, subsection 1 says that the district magistrate shall issue to the applicant under section 5 a certificate where they will be identified as a transgender, right? Subsection 2 says, and that particular form within the time that a person should be transgender or not, within the time that the district magistrate shall give the certificate. On the other hand, subsection 2, as you can see, the gender of the transgender person shall be recorded in all official documents with the certificate under subsection 1 and will be issued to the transgender person. The certificate issued to the person under subsection 1 shall confer rights and a proof of recognition of his identity as a transgender person. So before giving that person an approval of identity, all these things are required. A proof of recognition is also required, that whether he is a transgender person or not. So here lies an introduction to the gender, as rightly said by Stanford University. It is discriminatory and derogatory on the part of the Act, in sense this 2019 Act, as gender identity is a broad ambit, and can a district magistrate alone can decide that this person belongs to this identity? Transgender activists have criticized these provisions, have stated that it is faulty and derogatory in nature. The district magistrate, who is supposed to be a cisgender person, will take a decision of identity on behalf of a transgender person. That is very vague. A district magistrate will check the validity of the sex reassignment surgery. So they, before being a transgender, for example, they generally go for such surgeries that I've already mentioned prior. So the validity of that surgery will be determined by the district magistrate. So being a cisgender person, how can that magistrate understand that this person is a transgender person? On that basis, how can he or she will be assigned the transgender recognition? So the entire concept of gender gets violated here, as gender is not something that one is assigned during birth. It is biological sex that is one is given. So this is the foremost thing that the Act is not taking into consideration. The Act has placed his role in gender but not given importance in the gender identity, and rightly made that gender identity very narrow by giving entire power to the in the hands of the district magistrate, who will give certificate to the transgender whether he is a transgender, whether she will be a transgender or not. So Francis Corelli Mullane versus the Administrator Union on 13th January 1981 rightly says that, I have quoted these things: dignity and constitutional culture. So dignity and constitutional culture means constitutional culture gives us the dignity. So dignity is the essential part of our constitution. And that is why we generally mix with people. We express oneself. We are diverse in form. We are freely moving. We are mixing, we are mingling, we are commingling with fellow of human beings. So the dignity, the identity, all such things, all such heavy weighted words should be given importance. Just like that, coming into being such act and giving their names will be not enough. Section 4 to Section 6 of the Act, where Akai Padmashali in 2018 criticized the Act's definition of transgenderism, which states that transgender people are based on the underlying assumption of biological determinism. The Act seeks to set up a tedious procedure of obtaining the identity certificate by requiring they will go to the district magistrate. The district magistrate will screen them. There will be a screening committee. And thereafter, after screening them, the district magistrate will give them the recommendation, and the screening committee will give the recommendation to the district magistrate, and thereafter the district magistrate will generally issue them the identity certificate. This is the entire process. So is this the way that the identity of the transgender person, just like on the hands of the district magistrate, on the hands of the screening committee, is laid? It is not a self-discrimination. It is not a self-determination, which Nalsa Judgment is saying. So anyhow, it is not in toto with the Nalsa Judgment. It is contradicting the Nalsa Judgment. Supreme Court, again, to the where Barua have already given the plea. I mean, Supreme Court has already given the notice to that center on plea against the Transgender Act, January 28, 2020. The plea filed by advocate and trans activist Swati Bidhan Barua challenged the validity of the Transgender Persons Protection of Rights Act 2019, arguing that it treats the trans community with suspicion and reinforces prejudice against them. Rightly said by. The petitioner said the Act, instead of furthering or protecting the rights of trans persons, violates the right to equality, life, privacy under Article 14 and 21 of the Constitution of India. So beginning only, I told you that wherever we are all human beings. So Article 14, right to equality, right to life, Article 21, and under which right to privacy is also there. So all these fundamental rights are violated because the identity has been taken. It is only given in the hands of the district magistrate, where we, being a female gender, or you being the male gender, we don't have to go to a district magistrate and take our identity, do we? No. Then why for the transgender persons? Why such discrimination? Why there are so much lacunas? Last name cannot be changed. Even one thing, participants, that again has been stated in Section 7, Subsection 3, where it says that their first name can be changed, but their last name cannot be changed. In sense, the person who has been issued with the certificate under Section 6 or a revised certificate under Subsection 2 of Section 6, they are entitled to change the first name in the birth certificate. So wherever they are having the birth certificate name as the first name, they can change their name with all the official documents that are required, with affidavits and whatever the things are required, they can change that. But on the other hand, it says, suppose they change the gender identity, it is only the first name that can be changed by the transgender persons. Which raises the question here that why the last name cannot be changed, as to the sacrosanct position that the last name holds, and no provisions are mentioned so that the last name could be changed, thus making space for the regressive caste system and hierarchy in it is maintained. So the last name cannot be changed. Last name, why last name cannot be changed? Here, the question is giving much more space for the caste system. Hindu, Muslim, all these things, the last name generally, identification of a person. So why that thing is there? Why the last name cannot be changed? This is another line of lacuna which is there in section 7. Now, this is a principle which I was talking about in the Nalsa Judgment, that is Gadja Mada University in Yogyakarta. This is the principle that has been taken in the Nalsa Judgment as well, which was adopted on the application of international human rights law in relation to the sexual orientation and gender identity. So the Yogyakarta principles is a very vital principle which is talking about the right to privacy under principle 6, which was taken, that privacy is not something that only my private life. It is also the sexual orientation or gender identity is also involved in the privacy, which even includes my choice or my dischoice or the thing which I don't like, my likes as well as my dislikes, and the thing which I want to disclose, the thing which I don't want to disclose, the thing which is my decision, the thing which I don't want to take it. So all these things are there in that Yogyakarta principles under principle 6, which generally was adopted in the international human rights law in relation to sexual orientation and gender identity. The Yogyakarta principle had been enshrined in the Nalsa Judgment, which recognizes the different gender identities. So far, the Nalsa Judgment have also mentioned the existence of this Yogyakarta principles, which is mainly talking about gender identity, not only that, but sexual minorities and sexual orientations as well. So there are certain international conventions, such like UDHR, like the first foremost article which is talking about UDHR, where persons are born free, equal in dignity. Article 3 rightly says that everybody has a right to life, liberty, security of persons. Article 6 of the ICCPR, that is International Covenant on Civil and Political Rights, affirms that everybody has the inherent right to life. No one should be arbitrarily deprived of his right or life. Article 12 of the UDHR even talks about, and Article 17, both the articles of the one is talking about UDHR, and Article 17 of the ICCPR talks about that arbitrary or unlawful interference with his privacy, family, home, or correspondence is illegal. So nobody should do such things. Where we are saying such things, then why the act is actually having so much lacunas? The Indian Constitution, even these are the things we have discussed about the international one. The Indian Constitution, even Article 253, even says that the Parliament has the power to make law for the whole territory of India, implementing the treaty or agreement. And that is why the Yogyakarta principle has also been taken into the decision making here. Article 21 even talks about the personal autonomy. Personal autonomy as self-expression, which became an integral part of Article 21 of the Constitution of India, which talks about right to life and personal liberty. We should not be deprived of that. So, if we are talking about so many criterias, then again the question comes, why these are the act that came up in the year 2019 having so much lacunas? Article 21 in the Constitution of India 1950 ensures protection of life and personal liberty, which rightly says about that nobody should be deprived of the life. No one means no one, irrespective of any gender. So his life, personal liberty, except there are certain kind of clear provisions. Clearly the provisions validates that it depends upon the sole decision of the district magistrate, who will decide that whether that person is belonging to the transgender or not. So whether it is a right or whether it's a violation of right to life, thoroughly it's a violation of right to life. Because a person who is going through sex reassignment surgery or a person who is not going through such surgery, that is totally my decision that whether I want to become into that community or not. Who is the district magistrate to identify on behalf of me? Where Nalsa Judgment, where these kind of principles, even the Constitution of India is speaking about that there should be right to life, protection of life, personal liberty, we should not be deprived, equality, personal automation, all these things we are saying, then why such things? Section 12 of this act, in sense the act of 2019, subsection 3 is saying that where any parent or a member of the or the person of that transgender person is unable to take care of the transgender, then the competent court shall direct such person to be placed in rehabilitation center. So again a point needs to be notified here, that section 12 subsection 3 says that where a person who is a transgender and his or her family is unable to take care, then there is a rehabilitation center which the competent court will direct. Now in India, intersexual persons are stigmatized, and such stigmas lead to giving way of intersex kids to the hijra communities or torturing of them the family institutions in the form of mental and emotional abuse. There was one movie, I think Nagar Kirtan. I have watched that movie. I think many people or many participants here have watched even. This is one of the example I'm stating. Though there are certain kind of rehabilitation center, but whether or not they are getting that care or whether they are not, they are tortured by the society, still they are getting that rights from the society or not, that is a huge question. And that is, even with research, I can say that 20% if people can recognize, there are huge number of people who are still not recognizing them as the person in our society. So transgenders drop out of mainstream schools at a very early age because of the prejudice they face from the people around them. So the bullying them, torturing them. While the intention of opening the school is noble, the ultimate aim should be to integrate transgenders into society. But that won't be easy. Will it be? It is very tough. It needs to be aware. The people should be aware of it. The people should know. The people should understand that everybody is a human being. It is not only pen and paper that will determine that there are rights. It needs to be something more. It needs to be societal understanding. The society should understand. This is rightly stated by Anjali Gopalan, a LGBT activist, Murali Krishnan, in the year 2017, New Delhi. Even in April 2014, Justice K. Radhakrishnan declared that transgenders to be the third gender, as rightly brought by the Nalsa Judgment. Our society often ridicules and abuses transgender communities and in public places like railway stations, buses, schools, workplaces, malls, theaters, hospitals, they are sidelined and treated as untouchables. And forgetting the fact that their moral failure lies in the society's unwillingness to contain or embrace different gender identities and expressions. It is all about the mindset. It is all about our mindset that needs to be changed. Actually, it is high time. We should actually identify these people also are the human beings. We should raise our voice for them as well. Maybe the persons who are attending this webinar can understand there are other people across the globe as well who don't know. They are abusing them day by day. These things should be looked into. The mindset should be changed. With the history of oppression and crime towards transgender persons inside and outside their families, till now it is a threat to the transgender persons. With the act, their rights again become very narrow. Still, Nalsa Judgment, there was a hope for them. Maybe a better act could have come. But 2019 Act have narrowed their rights like anything. So there is no provision has been made to a different rehabilitation center as well. The section stands in contradiction because there is no as to transgender rehabilitation center exclusively given to them. So can you understand, with a gender person who is saying that I am a male or a female, with them a transgender person, can it be possible? There is no separate transgender rehabilitation center stated. These are the critics, Rachana, Samaria, and Philip C. Philip. They said that the clause rescue, protection, and rehabilitation, these three things are there in section 12. Rescue, they should be rescued, they should be protected, they should be rehabilitated. Now, the experience of trans persons in rescue and shelter homes, that is actually very worst. Extremely, you can say it is very worst, because they are facing mental, physical, emotional, sexual, all kind of violences they are facing. Secondly, from the earlier experiences where they are leaving their home, see, these people who are going to the rehabilitation centers or they are rescued, why they are going? Because anyhow they are thrown away from their house. They are not recognized as the person of their house or the family persons. They are thinking about their family. They are thinking about the society. That's why they have said that please go out of my house. They are thrown away of the house. They are neglected. So from the prior experiences, again when they are coming, they are again experiencing the same heinous kind of behavior. So don't you think that we need a restrictive thing? Their lives are becoming very restrictive. We need a more specific kind of protection for them. This is a council. Apart from the act, there was a council which was stated in section 16, clause G, that there should be a separate council for the transgender persons. But rightly see, there are 5 representatives of transgender community by rotation from the state governments, union territories, 1 from each north, south, west, east, and northeast regions to be nominated by the central government members. So in this national council, there will be these kind of representatives. This in itself is regressive in nature, as there is no or little indulgence of visibility or involvement of the transgender people. So these councils are for the transgender people, but there is no involvement of the transgender people here. So how will these people take the decision? The National Council lacks the kind of independence to carry out the function. So again, how they will be carried forward in the function, that also has been not laid. So the National Council, which is composed of 30%, at least 30 persons, has only 5 persons from transgender community. So can you understand, if 30 people, only 5 people from transgender and 25 people are from other gender, so definitely who will raise the voice? 25 people voice will be heard. Majority wins, we generally say. Do minority wins? Majority wins. So the council organized. Why it is organized? It is organized for the upliftment of the transgender person. But here I cannot find any kind of upliftment here. So that's why the question comes here that how far that the decision making adequately will help the transgenders while the persons are there in the National Council for Transgender Persons. Section 18 again has been criticized because this section is compelling in bonded labor, denying public places. This is discrimination towards the transgender persons for compelling in bonded labor, denying public places, forcing to leave household, other institutions, harms in way of sexual assault, physical abuse. All these things has been stated. The imprisonment for this is not less than 6 months, but which may extend to 2 years and with fine. Just see the penal provisions. It's only 6 months. Whereas Indian Penal Code gives a minimum imprisonment of 7 years and more for sexual abuses. Can you see the penal provisions given in Indian Penal Code? Whenever there is any kind of sexual abuses, it should not be lot less than 7 years. But here, can you see the penal provision? It's only 6 months. Why? Why such discrimination? The even Yogyakarta principles even talks about right to life. Now, it is questionable as it just not treats the transgender persons unequally, but also breaches the basic functioning of the Constitution. So where is that thing? Where is the punishment that has been duly stated by the IPC, and why not it is enshrined? Just because they are going to the third gender. Just because there is third gender written. Just because they are belonging to LGBT community. Why? Why we are sidelining them? And for others is 7 years? In National Human Rights Commission versus State of Arunachal Pradesh, even here also it was rightly quoted that rule of law, our constitution confers certain rights on every human beings. Every person is entitled to equality before law and equal protection of law. Then why such discrimination? Figures in National Crime Records Bureau even says that complaints are there. In 2014, the Bureau said that it started with Section 377 cases. And just in the year 2018, we have seen in 6th September that 377, if it is consensual, then it's decriminalized. So in 2016, the number had nearly doubled to 2,187. That year, again, 1,600 cases were sent for trial. So these were the cases that are actually, these are the criminal cases or abusement cases which are going against the transgender people, tracking Section 377, which is not consensual. Business Insider India interviewed by Preeti Soni in August 2019. The sad part was that I had no idea what rape even meant. All I know is I was brutally injured. A person, Nalsa Judgment, who is a transgender, who said this. So cases of rape and police brutality is common among transgender community, and it is actually breaching the law of the land, where there is no equality and no equal protection of the law. Police brutality and cases of rape are growing up, but for them, can you see the punishment is for 6 months. Maximum it can go for 2 years. Article 14 also talks about such things, but again, the question to this answer is 0 if we consider the act. Even guidelines stated in Vishaka, a very important case, a very landmark judgment regarding the sexual harassment in employment or workplaces. So where under Article 14, where sexual harassment of women in working places is relating to gender equality, which is relying on Article 11, 24 and general recommendations of Article 22, 23 and 24 of the Convention on the Elimination of all forms of discrimination against against women, I'm very sorry, then CEDAW, any international convention not in consistence with the fundamental rights and in harmony with its spirits must be going through these kind of articles which are there in Article 14, 15, 19, 21 of the Constitution. But the principles, even in transgender international conventions, including the Yogyakarta principles, are not found consistent with the particular act that has been recognized in the 2019. So the justification, if you see, there is no justification for that. So further, there are certain other ambiguities in the penal provisions that we have already mentioned. So here the dignity under Article 21 includes diversity of self-expression, which allowed a person to lead a dignified life. So self-expression, self-identification gives my dignity to live my life. My respect, my self-respect. I think if nobody gives me respect, I don't give that person respect. So I love myself first. So where there is no dignity, no self-expression, that does not mean a person is dignified or the person is leading a dignified life. One's gender identity definitely falls within the fundamental right to dignity under Article 21, which has been rightly which has not been given under this Act. So this landmark decision is legally recognized non-binary gender identities and fundamental rights to these kind of transgender persons in India. So Article 15 also talks about that prohibition on discrimination on religion, race, caste, sex, place of birth. So the penal provisions, that's why again and again the penal provision that has been given is rightly challenged and rightly unconstitutional, gender-based. So Article 15 and 16 are also talking about discrimination on the grounds of sex, gender, including gender identity. So I would say Section 18 of the Act 2019 is definitely discriminating Article 15, 16, 14, 21 of the Indian Constitution. So I would conclude my particular topic or particular discussion today by saying, again, the words by Justice K.S. Radhakrishnan and Justice A.K. Sikri. Discrimination on the basis of sexual orientation or gender identity includes any discrimination, exclusion, restriction, or preferences, which has the effect of nullifying or transposing equality by the law or equal protection of laws guaranteed under our Constitution of India. And hence, we are inclined to give various directions to safeguard the constitutional rights of the members of the transgender community, rightly pointed out by Justice Radhakrishnan. Even Article 14, which talks about right to equality. Even Article 19, Clause 1, Subclause A, talks about gender-neutral terms of all persons have the equality, freedom of speech and expressions. Even it would extend to transgender persons as well. Everyone. All means all, irrespective of anyone. So it drew attention to the fact that transgender persons subject to extreme discrimination in all spheres of society, which are violation of right to equality. Because the way the person's one's gender is identified by the way he dresses, not by acquiring his right to birth. By birth, a person's gender is never been taken into. It is considered by somebody's dress, by words, by action or behavior. So in a conflict between court judgment, Nalsa, and the legislation, that is 2019, that came up that we have discussed, it is the legislation that will take precedence. Till its constitutionality is challenged in courts, and such a challenge is accepted, and the absurd law is struck down, it is not novel concern that the law has been opposed to us and has continued to ignore our existence. What is surprising in this case is the law being used as an effective mechanism to validate our existence, but place us at a plane lower than that which is rest of the society rest on, thus legitimizing the violence that we are put through. We will continue to oppose this. So this is the words of the transgender community stating that wherever the judgment in one side if we take and one side we take the legislation will prevail, whatever it may be. The transgender people will oppose it because we even our discussion, while discussing it, we have seen there are many things which are lagging. Though we are saying right to life, though we are saying right to equality, though we are saying freedom of speech or expression, though we are saying that IPC, where stating just a simple sexual abusement will be going to 7 years of imprisonment. But here you have seen only 6 months, which can go for 2 years. So where lies the thing? So it is anyhow the law is opposing them. Why law is there? Why law is there? To protect every human beings. So here, the law is not protecting them. The law is simply ignoring their existence. In one particular district magistrate, who will give them their identity? So our throats cracked ages ago, hands bled and bodies tired. None of it has put a halt to our demand for what is rightfully ours. Through the fight, we spent moments mourning our losses. These weren't losses in courts or in legislation. These were the losses of our kith and kin. These were losses when our partners in the fight were stripped naked and paraded, their bodies examined, their bodies raped, bodies teared until they were blooded in shame, minds torn apart and pushed to them, taking their own lives. So the people, the transgender people, through ages they are fighting. Through ages they are loudly stating that please recognize us as a part of your society. We are also a part of human beings. We are also a part of human rights. We are also entitled to get the same rights as the other persons are getting, as the binary genders are getting. So our lives should also not be torn or shamed like whatever has happened. The act that has been enacted should be enacted for our protection, not just saying as the act has been protected just in pen and paper. There is an act, but it should be practically given some kind of recognition to them. In this particular case, Pretty versus United Kingdom, as well as another case, Croatia, this act has been implemented for the protection of the transgender persons turns out to be violative and identity as a whole. Time and again, the constitutionality of the act has been questioned, and it shows signs of discrimination and regression. So Article 19 of the Convention of International of the Human Rights says that where the notion of personal autonomy is an important principle underlying the interpretation of its guarantees, protection is given to a personal sphere of each individual. So each individual should be given the perspective of protection. There should not be any kind of discrimination. Last but not the least, I would say that in this 21st century, transsexuals to personal development, physical and moral security should be enjoyed by them. So in short, the act is totally unsatisfactory, and the act has situated an unsatisfactory situation in this post-operative transsexual lives. And it's not quite one gender or the other gender or other is no longer sustainable. So the court of Nalsa Judgment held transgender persons were entitled to fundamental rights under Article 14, 15, 16, Article 19, Clause 1, Subclause A, Article 21. All these things we have already discussed. Even there were international human rights treaties, UDHR, ICCPR, Yogyakarta principles to recognize the transgender rights. But these things were not enshrined in the Transgender Act of 2019. So, with the history of operation, the transgender bill was passed. So, the questions that I have raised here, that violence and trans discrimination towards the transgender community, a recent that act that has been made, the question that arises that whether the protest and the agitation was being passed in the transgender bill. Moreover, now, after the act came, why has been the constitutionality of the act being challenged by the various activists, lawyers, and other practitioners? And are the ambiguous provisions really protecting the transgenders? For all these answers, I would say all these things are gender identity, and gender identity in all the sections have been not mentioned anywhere. It has been shown that Article 19, Article 14, Article 15, Article 19, Clause 1, Subclause A, all these things were not present in the sections that we have discussed. So, this is somewhere or the other debatable, controversial, subjected to a lot of debate, subjected to whether it should be struck down or not. That depends upon the legislature. But from my side, I would say that there needs to be a lot more change, a lot more things, a lot more important things are lagging behind on in these kind of sections, which are the lacunas, which should be seen and which should be struck down, and there should be some kind of constitutional challenges should be made, which has been made, but there should be some kind of changes or amendments that should be done to those kind of provisions. So I would change with this. Gender. They said a transgender can't be a mother, but they forgot that motherhood is a feeling which means caring and loving without any boundaries. It's high time we realize the true usage of thrilling, pulling, and napuncircling in sense the transgenders. By this, I would say thank you, participants, and thank you, Manav, and thank you, Immortal India, for giving me this opportunity. Thank you, everyone.
So here we come to the end of this lovely presentation and a great webinar. Thank you, ma'am. Ma'am, there are some questions like, with your permission, I would like to address some of them.
Definitely. Yes, yes, definitely. Yes.
Ma'am, there is one question from Amanpreet Kaur. She's saying that whether transgender have any equal right as of male and female in Hindu undivided property, or there is any other provision made for them.
Any other provision made for the Hindu undivided family?
Like she is saying that whether transgenders have any right as equal, like as of male and female in Hindu undivided property.
No, that is also a thing which is lagging. Nothing has been mentioned in the act about from that there is any kind of rights given to them in the act, particularly that whether they will be getting the same rights like the Hindu or like female or male with the Hindu undivided family. But if you see that where the Constitution of India says that gender identity, right to equality, where male and female are getting such kind of rights, if you look into that, then apart from the act, if I say, they are entitled to get. But in the act, it has not been mentioned.
Next question is from Nilofer Bid. She says that what are the ways we can incorporate transgender rights advocacy?
Transgender right advocacy. That's a very nice. That's a very nice question, I would say. Yeah, definitely. By what way we can do such advocacy? That's very controversial, I would say. Now, advocacy means that public support or recommendations, right? So, I think somewhere or the other, people have already started doing such advocacies. Like many in my PowerPoint also, I've shown you that many activists, many people are fighting for them. And in near future also, I would see that with researchers, with many research and with my fighting these things, I think these kind of thing can be taken into account. So I think that public support or recommendation with transgender rights can be maintained through these webinars, these advocates or these people showing some kind of interest, going to them, taking their views, asking their views. So these kind of things can be put forward to the people who actually can do something for them. So I think that these advocacies can be done through the raising voice, even by them, even by us as well, because we are also the human beings. We are also somewhere or the other responsible towards the society.
Ma'am, this question is by Devarjun Day.
Huh.
He says that if any right of any transgender is violated, then where would it fall under the category of gender inequality or human right?
If any okay, let me say, if any right of any transgender is violated, then where would it fall under the category of gender inequality or human rights? Both, because gender equality or gender unequality is something very weird, but gender equality is there in the human rights. Gender equality is there even in our constitution. So both. Definitely, if a person is a transgender and his or her right has been violated, so that person will come under the human rights. After all, the person is a human being. That's the first thing. Thereafter comes the gender identity. So if I category that, definitely the human rights, and thereafter gender identity is a part of that human rights. Okay.
Ma'am, next question is from Jason Thosima. He says that how the transgenders are treated in jail and whether they are kept in any separate cell if they commit any crime.
No, no such cell or no such jail has been provided for them that is separate for transgender. Even no such rehabilitation center is also not there for transgender. That's we have already discussed. But it's a very nice question that where there is no such separate cell or no such separate prisons which has been kept for the transgender. So it's very problematic for them also to adjust with the other genders. So here the thing is that where comes their right to life, right to equality is, where see on the other hand we are saying that they are equal, on the other hand we are also seeking for a separate cell, on the other hand if they are not getting a separate cell also they are bullied or they are tortured. So the mindset should be changed. Actually, I think every human being should change their mindset that transgender are also the human beings. See, in this scenario also, if any boy goes to his mother and say, "Mom, I want to marry a transgender," first and foremost, the family will be in shock, and the family will think twice or thrice that whether that person will be my daughter-in-law or not. Same goes for a son-in-law as well. So this is the thing that we need to change our mindset. Yes.
One last question. Sutapa Das says that, Madam, what kind of workshops should be done which can be helpful for the transgender community?
Definitely. Yes, that's a very good question. See, what kind of workshop I personally feel, as because I am doing a PhD in relating to this transgender rights, especially in West Bengal, because it's not possible for me to go across the state borders and go, because that will be a very huge perspective for my side. So I have taken West Bengal. So what I am doing is like what I have made certain questionnaires. So I will be moving with those questionnaires, going to them and seeking that what kind of problems they are facing, because my total entire thing is an empirical research. So by these researches you can go through, by these kind of researches you can go, and now the everything is online, so you can fill up or fill some kind of Google forms, and you can go to their places. There are a lot of places where you can find, even in West Bengal, you fix up the areas where you want to go. So there are certain kind of people you will get, like transgender people you will get, who can tell you, even you can, if you are traveling by trains or even where you are stopping in the traffic signal, there you can find people who are coming. You can just take them, you can give them some food, they will be happy. They are very, they with many few little things they become very happy, which I have experienced. So with very little things they become happy, and when you ask them question, you need to ask them like your family. So you know, to get involved with them, definitely they will tell you what is their problem is. Just like that, they will not tell you their problem. Even if you ask me, I will also never tell you my problem. But when you definitely involved in my life, I will definitely share my things. So this is how you need to understand their I means mindset, their mentality, because they generally are fear, they are scared. They don't want to come to the public scenario. To come to that public scenario, we have to make them comfortable in their own strategy. So this is the way you can contribute to them, make some workshops definitely, and definitely they will come and tell you what is their problem.
Ma'am, before we end, like this is like type of message which you have to give in this question. What is the
Yes.
future of transgender in India? Kindly comment.
Future of transgender, yes, definitely. I would say again, future of transgender in the near future will change. Definitely will change. We have changed our minds. We are changing our minds. With the societal change, we are changing our minds. So again and again, I would say if the mindset changes, the transgender rights will be protected not only in pen and paper, it will be protected practically. So I would say again to everybody that if we change our mindset, see, if we think that yes, transgenders are also human beings, they are also belonging just like a same gender as we are. So if we think like that, I think everything will be sorted. So just like in pen and paper, in act, we just only getting an act and okay, transgender act is there. That is not the thing. It should be made in practice, and the mindset of the human beings also should change.
So here we finally come. Oh, there is another question.
Do you consider gender equality as a course to be taught to children in primary stages of schooling? Um that's I already stated in the PowerPoint that yes, definitely in schools, if it is good, if it is taught in primary schoolings. But see again, what is transgender, who are transgender, that also needs to be taught. See, if from the beginning only, if we see a person that he or she is from a transgender, then the students also should try to segregate. Then why such kind of courses will be there in the schools? Yeah, courses can be there of bad touch, good touch, those things can be there. That's the thing which you are anyhow telling the person to be secured, or telling the person to be yes, well known about the fact. But when a gender, it is like a normal thing. Why we are taking that gender into a, giving it a particular strategy, that thing is something weird. So that's why that needs to be read. That need not to be like this. It is also like normal, they are also normal human being. So I don't think so that if this course has been taught to students or children, then from the beginning they will try to segregate that we are this gender and that person is from that gender, and then again that they will be sidelined. So I think that this gender should be equal, like female and male gender is very common, we don't teach these things to students. Then why that particular thing should be taught in the schools? So this is the thing I want to tell.
So finally we come to an end to the session. Sorry everyone if we could not take your questions, because in few minutes we are going to start with another live event with we have an interview session. So once again a big thank you ma'am for being with us and giving us your lovely time today.
Thank you.
And thank you to all the viewers who were there today. And I hope you all had a great session. The feedback links have been shared in your WhatsApp groups respectively. So we'll be back again next week with another interesting webinar on how to deal with false cases by Advocate Lalit Ajmani. The details will be shared to you by our team. So thank you once again, ma'am, for being a part. And thank you to all the viewers. So till then, take care. God bless. And this is me, Manav Soni, signing off along with Koyel, ma'am. Thank you, ma'am. Thank
Thank
you,
you.
everyone.
Thank you everybody.